lot of information at you, including some technical phrases. Please don't let this throw you off. Feel free to pose questions. As Shauna said, feel free to get in touch post this session and we can discuss it in more detail. So without any further ado, today's session we will be covering the essential elements of employment contracts and policies, how to review and update your employment contracts and policies, and how to communicate these changes to your employees. So that's today's session. So as you may know, contracts are legally binding documents where your policy or your employee handbook is the Bible in terms of how the company operates and the conduct you want your employees to follow. So to break it down further for you, you are legally bound by your contract. That's why if there's a breach of contract from either party, so yourself or the employee, you can be sued for a breach of contract. There are a number of different contracts that you may issue to an employee, such as permanent, temporary, ad hoc contracts, specified purpose contracts, fixed terms, seasonal, annualized contracts, and apprentice contracts. And one that often comes up, a query around, is the young person's contracts. So it's important for you to recognize what type of contract you require, and it's important for it to reflect the actual day-to-day running of that relationship. So there's no point in issuing a contract, for example, to an employee, issuing a contract that is a 40-hour contract or 20-hour contract, whereas the employee works 40 hours. It has to reflect the actual practical side of things, okay? So the general rule that I would advise on is look back 13 weeks as a reference period to know what, kind of contract the employee requires if you are stuck in terms of you're not sure what contracts to issue to the employee. So the essential elements of contracts will go into a few of the terms, such as the implied terms or the statutory terms, implied terms, express terms. So the statutory terms of employment are referred to the Terms of Employment Act 1994, 2001, and it says that there should be 15 requirements within the employee contracts. These range from, the full names of the employer and employee, the address or registered place of work, the title of the job, the day of commencement, the rate or calculation of the employee's remuneration, any terms and conditions relating to hours of contracts, any terms relating to paid leave, pension, pension schemes, the period of notice that the employee is required to give you, which you're also bound by, okay? The implied terms, on the other hand, are not written or spoken, but it governs the employment relationship. So, for example, if you have been given employees 25 days a year of annual leave, you cannot simply just switch back to giving them 20 hours or 20 days after giving them 25 for the last 3 years, for example. So these are implied terms. The implied terms also are governed by the common law. So these are the duties that can be applied to the employer and employee. So examples would include duty of care, for example, or trust and confidence, or duty of good faith and loyalty. If the employer breaches any of these duties, then the employee may be able to pursue a civil breach of contract, okay? So the express terms, and I'm sorry I'm going really fast with this, but again, you will have time for questions after this. So the express terms clearly state that it can be in writing or orally, and these are terms, comments, agreements made at the interview stage. Okay, and then we'll go into the employee handbook. So once you've it is not an option to issue a contract to an employee, okay? You're legally bound to issue a contract within 2 months of the employee starting work. So you should use this time at the interview stage to negotiate the terms of the contract, okay? You also are bound by this act to issue the 5 core terms of employment within 5 days of the person starting work. So this will include their role, place of work, salary, payments, and the type of contract you're issuing. What I would say is kill 2 birds with 1 stone and issue the 5 core terms in the offer letter. That is the best advice I can give you here. But while we're on topic of issuing things, what I would also advise is that you have 28 days to issue the grievance procedure. So what I would advise on an employer taking in a new employee is once you issue the contract, issue the handbook, issue any other agreement that you have in place, for example, a deductions from pay agreement or training agreement, including the grievance procedure, send that off in an email and you have that box ticked. Okay, so once you have a receipt of sending everything, then you can just give the employee an opportunity just to come back with any questions or any feedback, just so you're covered on a 360 basis. So let's say that you don't issue a contract. Well, then that runs into its own problems. So for example, if you don't issue a contract, the employee can receive up to 4 weeks of compensation for your failure to issue a contract. But the way I would look at it is that you would never go into any formal relationship with anyone else without issuing some sort of agreement in writing. So I would treat this relationship the same way. And I always advise clients that, look, the contract will protect you more than it protects the employee. Most of the legislation is governed around employees, and it protects them more than it protects the employer. So let's have a good, strong contract in place and a good, strong policy in place so that you are protected. Okay. Now, once, of course, this is not a sales pitch by any means, but once you have Peninsula on board, they will make sure that you're covered on a 360 angle with regards to your contract and policies. So apologies there. Oh, technical issues. There we go. Employees handbook, policies and procedures documents. I've just gone through the contract side of things, and as I explained to you, the difference between contracts is that they're legally binding, where the handbook is it's constantly evolving and it's constantly changing in terms of procedural updates and those sort of aspects. However, your policies do form parts of your contract, and this is because the company may decide to include benefits in the employee handbook that wouldn't necessarily be stated in the contract. So, for example, you may have a bereavement leave policy, which states that you pay for the first 3 days of bereavement leave. This won't be included in the contract, but will be a benefit in kind in the policy handbook. So therefore, if you were to take it away, you need to get the consent first, because it will financially disadvantage an employee, and of course, taking any benefits away, nobody would ever be happy with. So consent and consultation is important there. Okay. Another reason you wouldn't include, you'd want to keep the contract very short and sweet. You don't want to overwhelm it. The contract should outline the 15 key terms in it, and then everything else will go into the employee handbook. Okay, and this is how you want the employee conduct themselves within the workplace. In terms of internal procedures, so this is what would govern, as I said, the conduct of an employee. If there's a breach, then you can act on it, but it has to be within the employee handbook in order for you to act on it. Okay, so we'll go through a few examples in a few slides there. Okay. Oh, apologies again. I keep going off my script because I do love the topic and I love to get into it. Again, the best way I would describe the company policy or employee handbook is your Bible in terms of how the company functions. So, for example, there are a number of policies you can see here on the screen, and that's my next slide. These policies may not be applicable to your business, and if you have Peninsula on board, what they'll do is on an onboarding call, your initial call, they'll go through all the policies that you maybe have and that you may be missing. So, for example, CCTV policy. People may think that this is not applicable for my business, and that may be the case. And signs around saying that there's CCTV around the place is a good starting point. However, a policy is what will give you the discretion, for example, to use any CCTV footage obtained through CCTV in any disciplinary proceedings. So, of course, we all know that you cannot monitor employees via CCTV footage. However, if, for example, an employee, is caught stealing from the business and you have that on footage, the only way you can use that evidence against him or her in a disciplinary proceeding is if you have a policy on it. So, again, these policies that you see here on the screen may not be applicable to you, but we will go through them individually and tailor them to your business. This is also your opportunity to set the standards you want for your company as well. So this list isn't exhaustive. There are also policies that I've worked on with clients, such as a good hygiene policy, something that's important to you. Let's say you're from a beauty business and you want a certain standard of appearance, and hygiene as well is important in everyday society. Or maybe a social events policy if you found that your employees go out quite often. So there's a way that you want to govern that. Of course, you can't govern what they do outside the workplace, but work social related events. The point here is that if there is a breach, again, that you are able to escalate the matter, but even bring up the conversation, because it places you in a much better position if you have a policy on it, rather than referring to no policy and just saying, look, you misbehaved, but what did you actually do? Where was the breach? And then you can refer to your employee handbook. Okay. So how to review and update your employee contracts and policies. So within Peninsula, we would update you on any legislative changes that come into effect. So for example, there is a sick pay bill coming in this year, and it will make sure that all employers pay all their employees the first 3 days of sick leave. Okay, so this will naturally have to be brought into a contract, and possibly your employee handbook will have to be updated. As I mentioned earlier on, before changing someone's terms and conditions, you will have to seek consent. Obviously, when it's an advantage for the employee, such as extra pay, nobody's going to kick up a fuss about it. But when they're being when a benefit is being taken away from the employee, then obviously that might cause concern, in which case you'd want to give them enough opportunity to bring their concerns forward. The best example that I can use here is that if you were to change, let's say, your contract with an internet provider that you have, you would first contact them and see what the story is, and then talk and discuss the change. Treat this exactly the same way. Okay. Now, so updating your terms of employment. If an employer wishes to change either in express terms or implied terms without consent, the question then becomes one of reasonableness. Okay, so in the consultation process with the affected employees, the main objective would be to secure consent. Apologies. The consultation process should be open, transparent, and there should be a rationale for the change. Okay, and that should be clearly explained. So it's not a case of, look, I'm changing the frequency of payments, and you don't give any explanation as to why that's changing. So context is very much welcome in this situation, and I would encourage you to explain it to the affected employees. Okay. Providing as much information as possible, even if it is a case of showing them, sales or turnover or profits, getting them included in that conversation, you have a bigger and better chance of implementing the change that you're looking for. Okay. So when you're updating your terms, as I said, the question becomes around the reasonableness. So what you should be questioning here, was the request to change versus was it reasonable for the employee to reject the change? So one would argue that, if my business is, for example, growing, I needed to change the frequency of payments, the example I used earlier. Well, I would have a clear justification as to why I'm changing this. So I would argue that this is a reasonable change. And while we're on the topics of change, as actually something just popped into my head, and there's this new legislation that's coming in, or a new EU directive that is coming in to put a limit of probationary period. So that means that your contracts will also need updating in line with the new legislation. Again, Peninsula can definitely help you on this one. Okay. So the question around reasonableness, so was the request to change a reasonable request versus was it reasonable for the employee to reject the change? Again, what we would do here on the advice line is that we would have a conversation around, well, why did the change? Why are you looking to make the change? How did you consult with the employees for this change? And did you explain the change? And then just look at the reasonable nature of the whole situation. Okay. Perfect. And then how do you communicate these changes to employees? My advice would be being transparent, number one. Employees, I found in my time with Peninsula and just in general with employees, they respect transparency and honesty. So just having that open dialogue with them, I think is a key here. The other side of it is, oh, sorry, there we go. Be transparent. Apologies. I'm very bad with these slides, so my apologies for this. Providing training is the second tip I would give you, and that is where necessary, provide training. So, for example, if you're introducing something new, ensure that first of all your top management is aware of this new policy that is coming in. Okay, so for example, a grievance procedure, a disciplinary procedure, your management needs to be trained on this, because if somebody lodges a grievance, you want them to act on it ASAP. Okay, it's very important for them to be efficient and also know when they can apply their policies, including one around disciplinary procedures. It's very important for your managers to know how to conduct a disciplinary process, and that you cannot just issue a verbal warning, for example, to an employee without going through a process first. Okay, so that's key one, and that's one that I found a lot with managers around the country, is that the idea of issuing a verbal warning, it's okay on the back of one conversation. No, there has to be a process, otherwise that verbal warning or that written warning that you've issued is unfortunately void. Okay. So where there's a change, it's important obviously to notify employees, and what I would suggest is informing all employees via an all staff email. If there is a contractual change, I would advise consulting with the employees during this consultation. Make sure that you minute the meeting. It doesn't have to be word for word, but it should be at least minuted in the sense of the bullet points that were discussed. And of course, give them an opportunity to provide feedback to you just on any concerns they may have or any questions. Again, during that consultation process, and what I would always advise clients is, you don't have to have the answer there and then. What can happen is have that conversation with them, note the questions, note the concerns, and say, look, I'll get back to you at a different point, and then consult with us on the technical aspects of a contract or policy change. Okay. Um, and of course, all these changes should be followed with appropriate documentation. So in a situation where you change someone's pay, for example, there's an increase or decrease in pay, follow this up with a contract amendment letter. This we will draft for you. We would help you obviously get the wording for it, send it to employee, you sign it, they sign it, and attach it to the initial contract. Okay. And two-way communication is key, as I mentioned earlier on. As with every concern, there's no point sweeping it under the rug. Address it, and address it properly with regular updates and communication. So if I tell you, look, I'm going to look into this matter, get back to the employee via email, have a recorded receipt of a conversation of the question that you've answered or concern you've addressed. Okay. And the other side of it is, be flexible with employees' suggestions. Sometimes employees will give good ideas or good suggestions, and bring good suggestions to the tables. Don't shut them down. Even if in your head you're thinking, look, that might not work from a practical point of view, that's fine. Note it, give them the time of day, and then we can address it or decline it or kindly reject it at a later point. Okay. Now, in relation to communication, it's important to have a communication policy update as well. You can post these new updates or policies even in common areas, common shared areas. I would also place them on SharePoints where it's very accessible. As I mentioned at the start, your first call of or first course of action is to send it via email, just so you have a written receipt of issuing the employee handbook, contract, deductions from pay agreement, etc. But from that point on, make sure that it's also accessible, because of course emails naturally get pushed down. So make sure that employees are able to access it at policies on a SharePoint or common area. I would also encourage everyone to just print hard copies, put them at the reception desk. Again, make it very accessible. Okay. The other side of it is that if your employee handbooks are accessible, the employee can turn around and say that, oh, sure, I didn't know that I had to call you 3 hours before my shift if I was feeling well. Because then you can turn around and say, well, look, I've issued you with the employee handbook. You've actually signed that you received it, and I see a red receipt here. We've also gone through it. So you can't say that you didn't know the policy around calling in sick. Okay. Now, more complex policies or procedural changes may require training, as I said, but training should be scheduled on an ongoing basis anyways, especially with your management, your top staff, because you want them to be the driver of these policies and enforce these policies when they have to. So it's important for them to know where they are. The policy handbook can range from 20 pages to 60 pages, dependent on how lengthy it is. We try to, in Peninsula, we try to keep them very tight and very straight to the point and very easy on the eye to read. So CCTV policy, it should only be about 3-4 lines long. There's no need to go into further details on it. However, your management should have consistent access to it and should be referring to them on a consistent basis. Okay, so it's important to get them trained again. Now, so Peninsula, of course, we're here for you 24/7. And although I don't specifically work in the documentation department, I am open to answering contract and employee handbook questions, including drafting them. Again, I'm geeky like that. I love that kind of work. But we do have a documentation department that will specifically spend time on your employees' handbooks and contracts. And of course, there is a side of health and safety as well that you need to be mindful of, as you see here on the screen. You need to make sure that your health and safety statements are up to date and your risk assessment is up to date. So that's where Peninsula will come in again from that point of view. That's all from me now. Thank you so much. I'm sorry for the glitches, the technical glitches again, but I hope you've enjoyed that. Thank you so much. Shauna, over to you.